Very frequently when we're dealing with personal injury and wrongful death cases, clients come to us and they are in situations where maybe the client or their loved one was potentially partially at fault for the injury. In other words, there's a defendant involved that has primary responsibility or certainly some fault, but maybe an accusation has been made, or just the reality is that the client or their family member who died shares some portion of fault for what happened. And so the question that they ask is, in Mississippi, if a decedent in a wrongful death claim or a plaintiff in a personal injury claim is partially at fault, can you still proceed with that claim? And the answer is yes. In a wrongful death claim, even if that decedent shares some fault or any fault, really any level of fault, they can still recover from the defendants that portion of fault that the defendants are liable for. Mississippi is what's called a pure comparative fault state. And to really understand what that is, we would have to compare it to the other option, which is a comparative negligence state, or contributory negligence state is how it's often termed, where under the law of some places, and as it once upon a time it was here, if the plaintiff, the victim, were injured, and if they had any fault whatsoever, even just 1% fault, any fault whatsoever, that used to be a bar, and still is in some places, from any type of recovery against the defendant. So if the defendant was 99% negligent, but the plaintiff was just 1% negligent and got injured, they still could not recover anything from the defendant. Some states modified that at one time, where if the plaintiff, as long as the plaintiff wasn't more responsible than the defendant, they could recover. So in other words, as long as the plaintiff was anywhere from 1% up to 49% at fault, they could still recover from the defendant as long as the defendant was more than half at fault. But what Mississippi has now is called a pure comparative fault. And what that means is that under any scenario, if a person is injured and another person has some portion, another person, another company has some portion of fault for that injury, that the injured person can recover for the percentage of fault that other defendant is liable for. So let me give you just numbers example. So say in a car wreck, that there is a situation where a jury, or in looking at the case, you can assign that there is 50-50 fault between the two parties for what happened. One party was not injured, but one party was. And let's say the party that was injured has $100,000 in damages, in medical bills and car damage and lost wages, etc., because they were injured, the other party was not. So $100,000 in damages to the injured party, but they are both 50-50 liable. Well, under that scenario, the party who was injured would be entitled to recover half of their injuries, half the value of their injuries, 50%, from that other party who is 50% liable. So the party who was injured would be able to recover $50,000 of the $100,000 in injuries from that other party who is 50% liable for the wreck. That's pure comparative fault. That's the law in Mississippi. And if you're in a situation where you've been injured and where fault is contested and where there could be some challenges to recovery, then it's important that you have legal counsel who understands the ins and outs of personal injury law in Mississippi, who has some experience successfully getting recoveries for clients in those situations, so that you have adequate representation on your claim. The Brad Morris Law Firm is available to answer your questions, and we offer free consultations on any personal injury or wrongful death claims. So we're available if you need us.